put you in the waiting room. I'm not sure what case you're here on because all I see is the name iPhone. While you're in the waiting room, look up how to unmute yourself. Okay, I'm going to put you in the waiting room. There we go. I'm not sure what case you're here. Good morning, Ms. Smith.
Good morning, Your Honor. How are you?
Doing good. Is that your client with you?
Yes, Ms. Lemoyne.
All right. Excellent. We're here on the case of Lemoyne versus Lemoyne, 21 DR 215. Please enter your appearance.
Good morning, Your Honor. Attorney Destiny Smith here on behalf of the petitioner, Ms. Ellen Lemoyne.
Good morning, Ms. Lemoyne.
Good morning.
Ms. Smith, we're here for a final hearing on an uncontested dissolution. Is there any reason we should not proceed today?
No.
All right. Madam Clerk, can you please swear in Ms. Lemoyne?
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Can you please state your name and date of birth for the record?
Ellen P. Lemoyne, January 24th, 52.
Okay. Please proceed, Ms. Smith.
Okay, and Ms. Lemoyne, are you a resident, current resident of Collier County?
Yes.
And have you been a resident for 6 months or more?
Yes.
Are you or Mr. Lemoyne a member of U.S. military?
No, we're not.
What was your date of marriage?
February 12th, 1983.
Okay. And is your marriage irretrievably broken?
Yes, it is.
Do you have any minor children?
No.
And I have to ask, are you currently pregnant?
Oh gosh, no.
Okay.
It'd be America, I'd be on Guinness.
Are you asking the court to restore your maiden name of Ellen Riley?
Yes, I am.
Okay. And did you enter a marital settlement agreement in this case?
Yes, we did.
And are you asking the court to adopt that marital settlement agreement and all the terms contained therein?
Yes, I am.
No further questions, Your Honor?
Okay. The court has reviewed the marital settlement agreement and also notes that the husband has filed an answer and waiver in this case. The court finds that has jurisdiction over the subject matter and the parties, that at least one party has been a resident of the state of Florida for 6 months prior to filing the petition, and that the marriage is irretrievably broken without any minor children. The court will therefore dissolve the marriage, restore you back to single status. The court also finds the parties have freely and voluntarily entered into a marital settlement agreement. The court will reserve jurisdiction to enforce the terms of that marital settlement agreement. And also the court will grant your request to have your maiden name restored. Its last name, I just want to make sure it's clear, is spelled R-E-I-L-L-Y?
Yes, it is, Your Honor.
Okay, then you will no longer be Ellen Lemoyne. You are now Ellen Riley. I have the final judgment before me and I am signing it now. Best wishes to both of you in the future.
Thank you, Your Honor. Thank you.
You're very welcome. Have a great day.
You too. I'll see you later.
Bye. Good morning, Mrs. Stramp.
Morning.
Good morning, Mr. Jameson.
Good morning, Judge.
All right. We're here today on the case of Stram versus Stram, 21 DR 191. Please enter your appearance.
My name is Joe Jameson on behalf of the wife, Mrs. Stam.
Okay. Mr. Jameson, I see that the husband has filed an answer and waiver in this case.
Yes,
that
he
correct?
has.
And we don't expect him to be here today.
No, Your Honor.
Is there any reason we shouldn't proceed to final judgment?
No, I believe we're ready to go to final judgment.
All right. Madam Clerk, can you please swear in Ms. Stram?
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Can you please state your name and date of birth for the record?
Tanya Stam, November 12th, 1967.
Okay. Please proceed, Mr. Jameson.
Yes. Tanya, you've been a resident of the state of Florida for at least 6 months prior to filing your petition for divorce,
That's correct.
and you're presently married,
Yes.
and your husband's full name,
Timothy Lee Stam.
and are you requesting that the court grant a dissolution of marriage today?
I am. Yes.
Is the marriage irretrievably broken?
Yes.
Do you have any minor children in common with Mr. Stam?
No.
Are you currently pregnant?
No.
Are either you or Mr. Stam a member of the military in the past year?
No.
You've entered into a marital settlement agreement that was filed with the court on February 1st. Is that correct?
That's correct.
Did that agreement resolve all the issues of your marriage?
It did.
And you entered into that agreement freely and voluntarily?
Yes, I did.
And you entered into the agreement after making full disclosure?
Yes, I did.
Are you requesting that the court approve that agreement and incorporate it into the final judgment today?
Yes, I am.
And are you requesting that the court restore your former name?
No, I will keep it as Stam.
Okay. Judge, I have previously submitted a final judgment to your office.
And I have it.
Okay, wonderful.
Okay. Anything else, Mr. Jameson?
I think that's everything I wanted to cover.
Okay. The court has heard the testimony and reviewed the file and sees that an answer and waiver was filed by the husband in February of this year. The court finds that it has jurisdiction over the subject matter and the parties, that at least one party has been a resident of the state of Florida for 6 months prior to filing this petition, and that the marriage is irretrievably broken without any minor children. The court will therefore dissolve the marriage and restore you both back to single status. The court also finds the parties have freely and voluntarily entered into a marital settlement agreement in this case. The court will reserve jurisdiction to enforce the terms of that marital settlement agreement. I've reviewed the final judgment that was submitted by Mr. Jameson, and I'm signing it right now. Best wishes to you, Mrs. Stam, in the future, and also to Mr. Stam.
Thank you very much.
Thank you, Judge.
No problem. Have a good rest of the day.
You as well.
Thank you as well. Thank you.
Bye. Good morning, Mr. Frazier.
Good morning, Your Honor. How are you doing today?
Doing good. How are you?
Can't complain.
And we're here today in the case of Jessica Ann Medlin versus Emmanuel Menz, 19 DR 2572. Please enter your appearance.
Yes, Your Honor. Jason Fraser with Family First Legal Group on behalf of the wife and petitioner, Jessica Ann Medlin.
Okay. Is there any reason, Mr. Frazier, that we shouldn't proceed to final judgment today?
There is not, Your Honor.
I see that an answer and waiver was filed by the husband, actually a while ago in November of 2019.
Correct, Your Honor. November 13th.
And do we have any expectation that he'll be here today?
No, Your Honor.
All right. Madam Clerk, can you please swear in Ms. Medlin?
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Can you please state your name and date of
Yes.
birth for the record?
Jessica Ann Medlin, 8/18/1978.
Please proceed, Mr. Frazier.
Thank you, Your Honor. Ms. Medlin, can you state your spouse's full legal name for me?
Emmanuel Apia Menz.
And you were married here in Naples, Florida on February 6, 2015, correct?
Yes.
Your petition for dissolution was filed November 13th, 2019.
Yes.
Have you been a Florida resident for more than 6 months?
Yes.
Are you or your spouse a member of the armed forces?
No.
Is your marriage irretrievably broken?
Yes.
Were children born during the marriage?
Yes. One.
Can you please state their name and date of birth?
Noah Emmanuel Medlin Menz, and he was born 5/5/15.
And that's May 5th, 2015.
Correct.
Are you now pregnant?
No.
Have you and your spouse entered into a marital settlement agreement and parenting plan that resolves all issues related to your assets and liability?
Yes.
Does this parenting plan resolve all issues related to parental responsibility, time sharing, and child support?
Yes.
You have been provided a copy of that agreement?
Yes.
Let me see if I can bring this up here. Can you see it on my screen?
I can see it.
Is this the copy of the settlement agreement that you filed?
Yep. Yes.
Is this your signature here at the bottom
Yes, it is.
and your initials on each page?
Yes.
Did you knowingly and voluntarily sign this agreement?
Yes, I did.
Were you under any duress or coercion to sign this agreement?
No.
Did your spouse knowingly and voluntarily sign this agreement?
Yes.
Was he under any duress or coercion?
No.
Your Honor, at this time, we move to admit the marriage settlement agreement with attached parenting plan.
It will be admitted.
Thank you, Your Honor. And Ms. Medlin, are there any assets and liabilities that remain to be distributed by the court?
No, there's none.
Do you believe that the parenting plan we've discussed is in the best interest of your son?
Definitely.
Are you asking the court to adopt your settlement agreement and parenting plan as orders of this court that require both of you to abide by the provisions contained within?
Yes.
Have all of the issues alleged in your petition for dissolution of marriage been resolved by your settlement agreement and parenting plan?
Yes, they have.
Are you requesting that the court restore any previous name to you?
Yes, I would prefer to be able to just use my maiden name, Jessica Ann Medlin.
Okay, and can you spell that last name for us?
It's M like Mary, E like Edward, D like dog, L like Larry, I indigo, N like Nancy, Medlin.
Okay. Thank you, Ms. Medlin, and Your Honor, I've got no further questions.
Okay. Mr. Frazier, the final judgment that was provided doesn't have the name change, so that one's going to have to be amended.
Okay. I'll make a note here.
Also, Mr. Frazier, I understand that there's a deviation request for the child support guidelines as part of this marital settlement agreement.
Yes, Your Honor, that is correct. We have deviated from the child support. The guidelines amount to a de minimis so that neither party is owed.
Would you like to elicit testimony from Ms. Medlin regarding the deviation?
Yes, Your Honor, thank you. Ms. Medlin, are you aware that a child support deviation has been requested in this case?
Yes, I am.
And that is based on the seasonal nature of your and your spouse's income, correct?
Correct.
Are you aware that this will result in neither party receiving any support?
Yes.
Are you all right with that?
Yes.
Okay. Thank you, Your Honor.
What is the nature of husband's work that's seasonal?
At this point, he's not working at all. When season comes and goes, he has work related to whatever odd job he's taking. Most recently, it was delivering for DoorDash and Uber Eats when things were busy with the holiday season. I'm not sure what he's doing. He's kind of back and forth with jobs all year long, whatever suits him at the moment and can bring him in some income. But I know he has none at the moment.
So at the moment he has none, but during season he is able to earn income
Correct.
through odd jobs.
Yes.
Okay.
I believe
Court-
he,
Yes,
I'm sorry.
No,
No,
please
that's
proceed.
okay. I believe he also, last year took a lot of time off of work for a knee injury as well. But typically it's definitely seasonal and it's minimal at best.
Okay. The court has reviewed the marital settlement agreement and also notes that the husband has filed an answer and waiver in this case. The court finds that it has jurisdiction over the subject matter and the parties, that at least one party has resided in the state of Florida for 6 months prior to filing this petition, and that the marriage is irretrievably broken with one minor child. The court notes that the parties have entered into a marital settlement agreement and a parenting plan freely and voluntarily. The court does find that that parenting plan is in the best interest of the minor child, and therefore the court will reserve jurisdiction to enforce the terms of both the marital settlement agreement and the parenting plan. The marriage is otherwise will be dissolved. The court also will restore your maiden name, and you'll no longer be Jessica Ann Medlin. Mr. Frazier, a couple things with respect to this final judgment before I sign it.
Certainly, Your Honor.
One, we need to add the fact that her maiden name is being changed and what is being changed to.
Correct, Your Honor.
Second
Working on
thing
that as we speak.
is that I do want specific findings, as the court does find that based on the evidence presented, that husband's income is minimal and seasonal, and therefore will accept the party's request to deviate from the guidelines pursuant to 61-30-11A4.
Your Honor, we'll have it to you within the hour.
Okay, thank you very much. Best wishes to you, Ms. Medlin, in the future. Or
Thank
not
you.
Ms. Medlin anymore.
May I ask one question?
Yes, absolutely.
It'll be a quick one. I believe I just might be able to be helpful in the name change piece. In discovering through the process, my driver's license actually is my maiden name still. So that may be why there wasn't a name change document, because it looks as though it was maybe never legally changed to begin with. I may legally still be my
You've
own
been
maiden
illegal
name.
this entire time? This changes everything.
Just to maybe spare you guys some of your sanity, it may or may not be necessary. I'm not sure.
Okay, well, I think all we're gonna need to do is just get a updated copy of the final judgment,
Correct.
which Mr. Frazier will have to us soon, and it'll be taken care of. Just want to make sure that the name change is a right spelling, because I have changed people's names to the wrong spelling before, and it is a pain. All right, anything else, Mr. Frazier?
No, Your Honor, that handles everything. Thank you so
Okay.
much.
Have a really good rest of the day. Best wishes.
You as well, Your Honor. Take care, Jessica. I'll call you in a moment.
Bye. Okay, thank you.
Bye-bye.
Good morning. Good morning. Good morning. You're still on mute. You need to take your thing off of mute. You got connected to audio, so that's a good start. Somewhere on your bottom left, you should see a microphone that unmutes you. It looks like a little microphone. It'll be red right now with a line through it. Hit that. All right, try to look up. I'm gonna put you back in the waiting room. Try to look up how to turn your thing off of mute. Good morning.
Good morning. How are you?
Doing good. Are you Mr. Kroll?
Yes.
Okay, excellent. Hold on one moment. Good morning,
Your
Mr.
Honor.
Castro.
Good morning, Your Honor.
All right. We're here today for a final hearing in the case of Kroll versus Kroll. Mr. Castro,
Yes.
please enter your appearance.
Jason.
Hold on one second. My clerk was gone. Let me get my clerk back. I need my clerk. All right, I got my clerk back. Mr. Castro, please enter your appearance.
Jason Castro on behalf of Matthew Kroll.
Okay, and I see Samantha Kroll. Are you there?
Yeah, I'm here.
Okay. You did file an answer and waiver in this case, so you don't have to be here, but you are here, so we will proceed. Mr. Castro, we're here today on a final hearing for dissolution. Is there any reason we shouldn't proceed today?
No, Your Honor.
All right. Madam Clerk, can you please swear in Mr. Kroll?
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Okay. Can you please state your name and date of birth for the record?
Matthew Joseph Kroll, October 24th, 1980.
Okay. Please proceed, Mr. Castro.
Mr. Kroll, did you file a petition of dissolution of marriage in this case on September 9th, 2021?
Yes.
Have you been a resident of the state of Florida for 6 months prior to the filing of the petition?
Yes.
Are you or your wife currently a member of the military?
No.
Can you please state the full name of your current wife?
Samantha Quinn Kroll?
Is Samantha Kroll present in this Zoom meeting?
Yes.
Were you married on March 5th, 2016?
Yes.
Can you confirm to the court of an approximate date of separation of February 15th, 2021?
No. It was earlier than that, but
Were you married in Naples, Florida?
yes.
Do you have any common children with Ms. Kroll?
Yes, we have 2 daughters.
Did you enter into a marital settlement agreement in this case on March 9th, 2021?
We did, yes.
For Your Honor, let the record reflect that a copy of the marital settlement agreement was filed with the court on April 8th, 2021.
Okay. I have taken judicial notice of the marital settlement agreement.
As part of does the marital settlement agreement resolve all issues concerning the division of assets and liabilities of the marriage?
Yes.
Does it resolve all issues concerning spousal support?
Yes.
Does it resolve all issues concerning the division of real property?
Yes.
Does it resolve all issues concerning parental responsibility?
Yes.
Does it resolve all issues concerning time sharing?
Yes.
To the best of your knowledge, is your wife currently pregnant?
No. Yet, to the best of my knowledge, she's not.
Are you asking that the court adopt this marital settlement agreement and that it become a judgment of this court?
I am.
Is the marriage irretrievably broken?
Yes.
Your Honor, I have no further questions for Mr. Cole.
Okay, thank you. Ms. Kroll, you did file an answer or waiver. Would you like to give any testimony here today? You're not
I don't think
required
it's
to do so.
necessary. Yeah, I don't think it's necessary, but thank you for offering.
Okay. All right. The court has reviewed the marital settlement agreement in this case, including the parenting plan. The court finds that it has jurisdiction over the subject matter and the parties, that at least one party has been a resident of the state of Florida for 6 months prior to filing this petition, and that the marriage is irretrievably broken. The court will therefore dissolve the marriage and restore the parties back to single status. The court also finds that the parties have freely and voluntarily entered into a marital settlement agreement, which includes a parenting plan. The court also finds that the parenting plan is in the best interests of the two minor children. For all those reasons, the court will dissolve the marriage, restore the parties back to single status, but will reserve jurisdiction to enforce the terms of the marital settlement agreement and the parenting plan.
Your Honor,
yes.
one more there was an additional finding I need. I apologize. I didn't lay the predicate for it.
No problem.
I just have to ask an additional inquiry of my client.
Okay, please proceed.
Mr. Kroll, are you asking that the court depart from the child support guidelines in this case?
Yes.
Are you asking for an upward deviation?
Could you clarify that?
An increase from the are you paying more than the statutory amount required at this time?
Yeah, at the moment, yes.
Do you believe that this upward deviation is in the best interest of the child?
I do.
Nothing further, Your Honor.
Okay. The court does find that the proper predicate has been laid for the upward departure from the child support guidelines, and that would be in the best interest of the children. Mr. Castro, have you supplied a final judgment yet to the court?
I shall. I just need to know if Ms. Kroll wants to change her name.
That is a great question. Ms. Kroll, are you seeking to have your maiden name restored?
Not at this time.
Okay. All right. Then that will not take place during the course of this one. If you need to do that, you can do that through a separate proceeding. All right. Best wishes to the family going forward, and especially the children. And I am extremely pleased that you all were able to work together to resolve this case that had been very contentious. I hope that it is not contentious, Your Honor, going forward.
This was not a contentious case. That was a different case, Your Honor.
Okay. All right. Thank you all.
Thank you, Your Honor.
Thank you.
Thank you.
Bye. Let me try this guy again. Good morning.
Morning, Your Honor.
All right. Mr. Cliff, who else is supposed to be in the Zoom room? Is there a court reporter on this one?
Yes, we should have Madam Court Reporter. Mr. Irwin, did you order one as well?
Okay, I got one for I got one here. I also have a court reporter, Betty Althoff. Does anyone know if that one is for this case?
We'd ordered one from Merit Court Reporting.
Our court reporter is already on.
Okay. Well, let me see who this one is. All right. And is anyone expecting anyone else here? Is Mr. Koger going to be here?
I left it at his election, being that it was probably going to be a non-evidentiary hearing. So I don't believe we're waiting on him.
Okay. All right. I think we got everybody we need. We're here on the case of Balzas versus Koger, 20 DR 2068. Please enter your appearance.
Attorney Matthew Irwin for the former husband, Jay Koger.
Good morning again, Your Honor. On behalf of the petitioner, former wife, Adrienne Balaz, who is present.
Okay. All right. Mr. Irwin, we are here on your client's motion to dismiss.
That's correct.
All right. Would you like to proceed to argument?
I would. Your Honor, the parties have one minor child together. Benjamin is age 6. They have a final judgment out of Guam, and that was entered April of 2019. After an evidentiary hearing, the judge in Guam ordered a 2-year rotation for Benjamin. He began his 2-year rotation first with Adrienne, and that is set to conclude June 27th when Mr. Koger is set to begin his first 2-year rotation. After the 2 initial 2-year rotations, the judge believed that it would likely not be in the best interest of the child to continue with that rotation too far beyond 1st, 2nd, 3rd grade. So it's kind of contemplated that this is going to be modified in the future, depending on where the parties are. My client remains, he's part of the Navy, and Ms. Balaz, she relocated to Collier County. So the court couldn't really tell where the parties were going to be at the end of these 2-year rotations. So the foreign judgment was registered on October 28th, 2020, and then the subject pleading was filed January 12th of this year. There's really only one sole allegation as far as a substantial change in circumstance that comes on page 3 of 5 in paragraph 11. And I'll quote, it says, specifically, the former wife asserts that the subject minor child at his current age, 6 years old, has evidenced separation anxiety and high levels of distress due to the current equal time sharing arrangement. And based on that, she's asking that she get now the bulk of the time sharing and that she be awarded the school-based parent. So we didn't feel that looking at the case law, and I cited to some of it in the motion, I filed it with the court on April 30th, that is meeting the pleading requirements first announced under Wade v. Hirschman, that we have a substantial material and unforeseen change in circumstance. In our opinion, there may be some concerns or anxieties the child may have. We're not aware of that, but in our opinion, separation anxiety with younger children, 6 years of age, is really a common thing, going from one parent to the other. We question, why does the child know so far in advance? The pleading doesn't discuss, has there been any therapy that's been done? That therapy has failed. The child is saying the following things or exhibiting the following specific symptoms, just simply that we have separation anxiety. So we didn't feel that it would be worthy of the party's time or the court's time to proceed all the way to trial, and then they prove that the child is having some separation anxiety. We don't feel that's enough under the case law.
Mr. Irwin, can I guess I have a more fundamental question. Isn't the fact that there was a move in and of itself the substantial change in circumstance?
No, the move was contemplated. If the court reviews the parenting order, the court was already aware that the mother was moving to Collier County. And that's why the court set up this 2-year exchange in the first place.
And then in the in the final judgment, doesn't it say the schedule should continue for at least one cycle of rotation, 4 years total, after which the parties may petition the court for shortening of the cycle or for any other modification of the custody agreement?
Yes, but my client has not even began his 2-year cycle. So the court is contemplating 4 years, and that's not occurred yet. So it was contemplated mom would have 2 years, dad would have 2 years, then they sit down and talk about a modification. The mother is seeking to take away my client's contemplated 2-year rotation based solely on the fact that the child is having some separation anxiety. The child hasn't even experienced this rotating schedule yet. I would note that this isn't 2 years completely without the other parent. I know the court might have some concern about that. The child is to spend time over the summers with the other parent. So it's kind of a long distance parenting plan with Christmas and other things built into it. So we don't feel that there's really a pleaded substantial material and unforeseen change in circumstance. If you look at case law like Korkmaz versus Korkmaz, even parental alienation, extreme disagreements, inability to communicate, that's not enough. Here, the child having some level of separation anxiety, it's really not well pled or specifically pled, in our opinion, is not meeting the pleading burden. So we would ask that the court dismiss the supplemental petition for modification, allow the exchange to occur on June 27th as contemplated, and award attorney fees. We're just asking for entitlement today under 6116 and the Rosen factors.
Okay, thank you. Mr. Cliff?
Thank you, Judge. Of course, we would not agree with the presentation and the motion filed by the former husband, and we would ask the court to deny the relief being sought. Of course, Your Honor, we are traveling under the seminal case of Wade versus Hirschman, Supreme Court of Florida case 2005. So Mr. Irwin and I have been utilizing that case and its progeny for the past 16 years. So when we both go about filing a supplemental petition to modify a parenting plan, we're well aware of the criteria, substantial material change of circumstances, not contemplated at the time of the entry of the final judgment. And then if we meet that hurdle, then we can look at the best interest factors as set forth in 6113. The issue here, Your Honor, is that we have a couple who have been separated since 2017 when the child was only 2 years old. The child is now 6 years old. In review of the final judgments from the country of Guam, and why I say final judgments, there's a final judgment of dissolution of marriage, and then there is a detailed order concerning what we would, I guess, call a parenting plan that is findings of conclusions and findings of fact. And that was entered by the Guam court on March 29, 2019. The issue, Judge, is that if you read those two orders in conjunction, the parties have actually agreed on all aspects of their dissolution of marriage, in Guam called a divorce. The only issue was custody, and they used that term custody. And during the parties' separation, they'd actually agreed on a week on, week off parenting plan because at that time, both of the parties lived in the country of Guam. The problem, Judge, is that when the child was 4 years old, the court ordered this, lack of a better term, unconventional, I have other words for it, but euphemistically unconventional, that called for 2 years with one parent, 2 years with the other parent, and the only time that the other parent would see the child would be twice per year. We have one parent who lives in Florida. We have another parent who lives in Hawaii, great distance. I know Mr. Irwin keeps on referring back to paragraph 11 of our pleading, which is the substantiate paragraph within our supplemental petition to modify. And paragraph 11 not only speaks about separation anxiety, which is true. Maybe when the child was 4, that was not contemplated, but certainly we also put high levels of distress. We would have liked to have put more, Your Honor, but we cannot really talk about a child's psychological or mental health. That, of course, is the rules of evidence, 90.503, and the child was recommended for counseling by the child's school counselor. So the child has not only expressed to the school and counselors of the high anxiety and the distress, and the reason the child knows about this is because the child was having parenting time with his father over the Christmas break, and he is now aware of this transition. It is going to be occurring in about a month and a half. And this is not something that the former wife is saying, no, hold off on this right now. She has every intention on following through with the court order. She followed through during the Christmas break. They made plans for the child to go to Hawaii, where the father wishes to have the child. But once this happens, the child is going to be with the father for 2 years. And we believe that based upon the child's behaviors in school, the guidance counselor, and he was referred to another counselor who the child has been seeing, we believe that it is inevitable that this needs to be looked at again. And we think that it needs to be looked at right now. And whether or not we prevail at trial, we don't know. But as far as the pleadings are concerned, we believe that we've complied with Rule 1.110. We stated a cause of action, short, plain and simple, ultimate facts. And Mr. Irwin is aware of the previous judgments from the country of Guam and the parenting plan. And we have stated that there has been a substantial material change of circumstances. The child is having anxiety, high levels of distress. And again, we have pled those sufficiently. We have put them on notice. We have stated the ultimate facts. And because of that, we believe.
So the two change of circumstances that you're alleging are anxiety and high levels of distress in the child?
That's correct, Your Honor.
Is there anything else?
Well, Your Honor, we can't really reveal that because that would be psychological patient privilege. And the child has been seeing a counselor, Kendria Brown. It had been our hope that we could go to the next level where we would ask for.
That's evidentiary.
It is.
But that's evidentiary on what high levels of distress or anxiety, right?
Correct. So we'd like to be able to prove our case in the right forum, and we would need an attorney ad litem to be appointed. Again, when you're talking about anxiety, distress, and the child having these issues concerning the parenting plan, necessarily it should not come from a parent, it should come from the experts. The only way you can get the experts to testify is the appointment of an attorney ad litem. The attorney ad litem would then make recommendations.
No, I got what you're saying, Mr. Cliff, but what you're talking about is the way you would prove what you've alleged. What Mr. Irwin's talking about is whether what you've alleged is sufficient for me to find a modification.
Right.
And I rebuttal.
Well, if I could finish, Your Honor. And again, I know that we're free to amend, but again, I don't know how it could be without revealing privilege to the child without the attorney ad litem. I don't know if I can really go any further on our pleading, and it does put them on notice of what we're looking to accomplish. And again, the larger picture, Judge, is that it was contemplated that sooner or later this have to be done because the judge even said this cannot be a permanent type of plan. Yeah,
but it was contemplated after 4 years. What you're saying is like right after her time was done, now changing it?
Actually, Judge,
that goes completely against the intent of it.
A year and a half later, when the child wasn't even in school. Remember, Judge, the child was only 4 years old. The child has been going to school here in Colorado County, has gotten older, and he has.
I'm not questioning whether or not the plan that was implemented in Guam was in the best interest of the child. I don't even know if that's what my role is.
Not yet, Judge.
I think I can just. I don't.
That's
think
correct.
I can do that with just a substantial modification.
That's correct. You cannot look at best interest until we can prove, and that's why we have the opportunity to prove to the court our pleading, and we have stated our basis for the pleading. We have stated the facts. They don't have to be in great detail. They don't have to get into psychological issues that are important to the child but should not be revealed in pleadings.
I got it. So basically, I need to go back and I'm going to be reviewing the case law, and I'll see if what you've pled, which my understanding is the only substantial change in circumstances that you were pleading at this time, is anxiety and high levels of distress, and whether or not that's sufficient under the law to proceed forward on the supplemental. I think we were only scheduled for 10 minutes today.
30 seconds, Your Honor?
Yes.
I would just note that if they wanted to file a more detailed pleading, as I think they would need to do, if the case were to proceed, they can seal the pleading if they want to have any confidential information put into it. Also, if they proceed all the way to trial, maybe 8 months to a year from now, and they prove separation anxiety and distress, what is the proper relief in the best interest of the child? Is it to take the child away from the father, or is it to get a proper treatment plan put into place? So I just think even if they prove these allegations.
I don't know. I need to get back to the case law. and see whether or not this is enough. But either way, this doesn't seem very well thought out. Because if it's close now and we get to trial, I'm not sure what you would expect to happen, Mr. Cliff. But, and
Well,
if
again,
I
Your Honor,
do grant your motion, Mr. Irwin, then Mr. Cliff is just going to amend if there is more. So I'm not sure what the best course here from a practical perspective is, but I need to look at the case law to see whether or not you met the burden under the motion to dismiss stage, Mr. Irwin. And I'm going to reserve at this point, and hopefully get back to you all with a ruling as soon as I can.
I thank the court for its time.
Okay.
thank you, Judge. Sorry for going over time. Well, I guess we were okay on time. Thank you, Judge.
All right, bye.
All right, bye-bye.
I don't have anybody else in the room. I thought we would have another one right now. So I'll be back in a couple minutes.
Okay.
Good morning.
Good morning, Judge. How are you?
Good morning, Your Honor.
Good morning.
Morning, everyone.
All right. We are here today on a motion to dismiss that's been filed in the case of Whitehurst versus Wiley, 20 DR 1972. Please enter your appearances.
Good morning, Your Honor. James Shell on behalf of Perry Wiley.
Brian Silverio on behalf of the former wife, Mary Whitehurst Bean.
Okay. Are we expecting Miss Whitehurst Bean? She doesn't need to be here, but
No, Your Honor.
if we're expecting her. Okay. All right. Before we begin, Mr. Chandler, has there been any discussion with Mr. Silverio about this motion, or are we proceeding today to hearing?
Oh, I believe we're proceeding today. I don't believe they're willing to agree to it.
Okay. All right. Mr. Chandler, please proceed to argue your motion.
So I don't want to reiterate my motion. It kind of speaks for itself as far as the timeline goes. They were granted a dissolution of marriage, or they call it a divorce in Mississippi, I suppose, back in 2007. Subsequent to that, my client moved to Erie, Pennsylvania. The judgment was domesticated there, modified. There was a Pennsylvania order modifying. And then at some time, and that was in 2014, at some time since then, my client has relocated, just as the wife has, relocated out of Mississippi. I believe she moved somewhere else, and then she ultimately has landed here in Collier County, Florida. My client has landed in Las Vegas, Nevada. And the wife has domesticated the Mississippi order here into Collier County, Florida, as well as the orders from Erie County, Pennsylvania. The wife is now seeking enforcement action here against my client. My client is not a Florida resident, has not been a Florida resident, has no intention of becoming a Florida resident. And the issue here is whether Florida has jurisdiction over an out-of-state resident who's never resided here, never availed themselves to the protections of a Florida court. And it's our position that he has not availed himself to a Florida court. And if she wishes to domesticate this for enforcement or modification purposes, normally the rule of thumb is the money follows the payor and the parenting follows the child. That's why you can have cases going in two different jurisdictions. And in this case, the payor, which would be my client, would follow him to Nevada, not to Collier County, Florida, that he's never resided in and has no personal jurisdiction over him. Now, I will, and as far as the timeline goes, I think the motion speaks for itself. The former wife, through Mr. Silverio, filed a response on Friday, essentially alleging that they have complied with Chapter 55, which is the domestication statute, specifically 55.505. The problem with that is I would submit nothing but a mere head fake in the issue of jurisdiction, because what 55.505 deals with is incorporating or bringing in a final judgment from out of state, which you certainly can do. What it does not deal with is the issue of jurisdiction over an out of state respondent. It does not confer jurisdiction in Florida over a foreign citizen. That it does not do. And if you read 55.505, 1, 2, and 3, it's not a long statute. Nowhere in there does it confer jurisdiction over someone who lives out of state. Now, where this would absolutely apply is if my client were a Florida resident, or if you had any judgment from out of state and that person lived here in Florida, that you would domesticate that foreign judgment here for enforcement purposes on a court that has jurisdiction already. Not that, well, we're going to domesticate it here and we're going to let him know, and if he doesn't do something, we now have jurisdiction over him. That's not what that statute says at all. And the problem here is they're trying to say, well, he didn't object to it being domesticated. She could go to any state in the country. It doesn't mean that that state has jurisdiction. If that were the case, Florida now has jurisdiction over everybody on planet Earth. if you think about it, we got to bring a judgment here, even though they never set foot here, and a Florida resident can give jurisdiction to a Florida court. No, that's not what that statute says at all. So Florida does not have jurisdiction over a Nevada resident who's never set foot here to enforce anything. And if she needs to enforce it, I would submit that the proper venue and the only court really with jurisdiction right now to enforce this would be in Clark County, Nevada.
Okay.
And for those reasons, we're asking that the court dismiss the enforcement proceeding or dismiss the motion for enforcement.
All right, Mr. Chandler, can you, you may have already, you did touch on it, but I'm not sure I'm following it. Can you address the waiver argument? The fact that under the statute, there was a requirement to file some sort of something within 30 days, and he didn't do that?
But it still doesn't give jurisdiction. The court still has to have jurisdiction.
Then what's the point of the timeline?
The point of the timeline is that if you have someone who the court does have jurisdiction over, say it's a Florida resident, okay, we have an individual that lives here in Collier County, and say you're, I'm just going to, for hypothetical purposes, I'm going to say it's Wells Fargo, and Wells Fargo has a judgment against me from Tennessee, and I moved from Tennessee down here to Florida. And Wells Fargo says, you know what, I'm going to take my Tennessee judgment because you don't live here anymore. I can't really enforce it here. I'm going to domesticate it down there in Florida over a court that does have jurisdiction over you because you did move to Florida. And, you know, they domesticate it, they provide him notice, and he does have 30 days to object. That's true, because the court would have jurisdiction over someone who's here within our borders of the state of Florida, or who has.
Then how would he object to jurisdiction under your scenario?
You could object.
There would be an objection to jurisdiction.
You always have the right to object to jurisdiction. So that individual could object. It may be a non-well-founded jurisdiction, or I'm sorry, objection. It may be non-well-founded.
Yeah.
But just like on certain subpoenas, you always have the right to object to a third-party subpoena, whether it's well-founded or not.
Let me rephrase that. Why would you have a meritorious objection to their jurisdiction under that scenario?
It just says you have 30 days to raise that issue. You may not have a meritorious, and in fact, most of the time on third-party subpoenas, you don't have a meritorious objection, depending on what it is. I'm not going to say always, but it doesn't confer jurisdiction on somebody that's not here.
Well, let me ask you this: is there any dispute that he did miss the deadline under the statute, Mr. Chandler?
I'm looking at the. I mean, I don't know that he necessarily objected to it. And I don't, so in all candor, I don't believe that there was an objection filed, but I don't know that he needs to file an objection when the court doesn't have jurisdiction over him. Because if that was the case, what state, now he is in a position that whatever state he goes to, he's got to go and follow their law. What if she went to Montana? He'd have to try to figure out what the law is in Montana to follow it. He's not availed himself to the law of Florida, to the law of the state of Florida. So why would he need to follow our statutes when we have no jurisdiction over him?
Well, let me ask you this. What is the court to make of the fact that I think I understand that he has been paying child support through the state of Florida?
So what happened there is, you can see that in the Pennsylvania order. Pennsylvania says, we're getting out of this. We're going to send our file to Florida so that Florida can be the collection agency. And just the fact that he sent a payment to Florida does not give Florida jurisdiction over him. Give you an example. I go do business with Lowe's, okay? And Lowe's is the credit card that I have. I do business with Lowe's here in Naples, Florida. But Lowe's is, they're billing departments in North Carolina. And that's where I get my bill, and that's where I send my bill to. Is Lowe's going to sue me in North Carolina? I've never been to North Carolina. Just because I paid my bill to North Carolina, I did my business here. So I don't think that in itself, just the fact that he paid a bill that went to the state of Florida, that availed himself to the jurisdiction of a Florida court?
No, but under your scenario, if they did serve you of a lawsuit in North Carolina, and you didn't file a motion to dismiss based on jurisdiction, then yes, the court would obtain jurisdiction over you.
But we did file.
Why isn't that different? Why is that any different from this scenario?
But we did file a motion to dismiss.
Yeah, but not within the required time frame under the statute.
But that's if you have jurisdiction.
No, that doesn't make sense.
How would somebody? But nobody filed a lawsuit against Mr. Wiley. Nobody filed a lawsuit against Mr. Wiley. They just said, "Hey, we're incorporating this judgment here."
All right.
Nobody said we're seeking relief from a Florida court. That was never told to Mr. Wiley until they filed this motion. So that wasn't a lawsuit being filed.
All right, Mr. Chandler, anything else?
Well, just you can't expect an out-of-state citizen to know the law in every state and to comply with a state that he has no jurisdiction over him.
Okay.
So,
all right. Mr. Savario, I'm sorry, I didn't mean to cut you off, Mr. Chandler. I thought you were done.
I was, Your Honor. Thank you.
Okay. Mr. Savario, please proceed.
Thank you, Your Honor. Let me just try to pull up one answer for you so you have it here. Okay. Your Honor, there are, did you get a copy of my response?
I did.
Okay, thank you. Mr. Chandler has spelled out the history of the case. There are three bases, I believe, to which establish jurisdiction over the defendant, the former husband. One is we follow the procedure under Chapter 55, and it renders the judgment fully enforceable here in Florida, establishes jurisdiction as it would any other judgment obtained here in the state of Florida to pursue the enforcement of the judgment. To address the court's specific inquiries, if you look at Chapter 50509, it deals with the 30-day deadline after the foreign judgment is recorded, for the judgment debtor to file an action contesting the jurisdiction of the court which entered the foreign judgment or the validity of the foreign judgment. Now is the time, that was the time for him to do something. That was the time for him to speak up and actually file his motion to dismiss based on jurisdiction. And we know this, Your Honors, because if you look at Chapter 55605, entitled Grounds for Non-Recognition, 1B and C, it says an out-of-country foreign judgment is not conclusive if the foreign court did not have personal jurisdiction over the defendant or the foreign court did not have jurisdiction over the subject matter. So it spells out in the statute defenses that a judgment debtor has to a potential domestication of a foreign judgment. The opportunity for Mr. Wiley to contest this and to raise the jurisdictional issue has come and gone after the expiration of the 30 days. I've attached to the response, and it's been previously filed with the court, the notice from the clerk's office, not from my office, from the clerk, of the recording of the foreign judgment and the delivery of said foreign judgment to Mr. Wiley's address in Nevada. The onus was on him to take care of that and to file a response to that in a timely manner. He did not, and as such, so long as the former wife is in compliance with Chapter 55, we believe that establishes jurisdiction over his failure to raise that issue. Secondly, Your Honor, when we're dealing with these jurisdictional issues, it is incumbent upon the person challenging jurisdiction to file an affidavit challenging the jurisdictional issues. Mr. Wiley or his counsel failed to do that. They have not shifted the burden. Had they done so, the burden then would have been shifted to our side to show why jurisdiction has been established. They failed to do that. I've cited a case out of the second, this Green-Spryer Global case, which talks about that they must file affidavits in support of their position. Their failure to do so also renders or allows this court to deny the motion to dismiss. Third, Your Honor, under this statute, the case law that we cite in there, Pratt versus Equity, talks about how when we're trying to enforce a final judgment, it's not a question of personal jurisdiction being acquired. It's whether or not you've done the proper procedures to domesticate the final judgment and treat the final judgment as if it was valid here in the state of Florida. The case law that I cited in there goes through that example. In the distinction that Mr. Chandler makes in some of the cases he cites deals with the modification of a final judgment, which we are not doing. We're not seeking to modify any of the child support orders or any of the parenting plan or the marriage settlement agreement or anything like that entered in either Pennsylvania or Mississippi. So for that reason, Your Honor, jurisdiction was not even required under, as long as we did it the right way. Lastly, Your Honor, as Your Honor pointed out, he is making payments, child support payments in the state of Florida. There is an active pending DOR proceeding. And so what we're seeking, Your Honor, part of what we're seeking in this case is uncovered medical expenses, things of that nature, which are in the nature of child support, which are listed, and I cite the case Clark versus Clark, which talks about how medical and dental and prescription items fall within the category of child support. It needs to be noted on that level that this is not some random state, as Mr. Chandler suggests, that the former wife would be willing to go to any state in the union to get this done. He has a connection here. The wife lives here. The children live here. One of the children anyway, while not in school. The child support payments are due here. And so it's not some random state where we're just dragging Mr. Wiley in court to court across the United States. As Your Honor is well familiar with the general case law under general civil litigation, these claims arise and jurisdiction arises where payment is due. So if you have a contract and there's no venue provision or there's no state that says where the action is going to be filed, where does the cause of action accrue? The cause of action accrues where the payment was to be made.
Do you have a case in the family law capacity or the family law similar to this, where jurisdiction was found just based on the fact that the support payments were being made to the state?
I looked, I didn't find one in a family law setting. They're obviously in commercial transactions where the payments to be made. But I see no reason why the court would treat it any differently, especially in light of the fact that there is a pending DOR proceeding. I've attached a copy of a most recent pleading that was sent out to both parties, establishing that either party can move to modify it at that time if they chose to. It establishes a payment amount. It establishes jurisdiction. If he didn't make a payment for his child support payment, the DOR would be well within jurisdictional rights to pursue, set a hearing, file a motion in this very court to proceed against Mr. Wiley for child support issues. What we're seeking is in the nature of child support with regard to uncovered medical expenses and the like. Part of it, the college expenses, I would acknowledge we're not, but we're here, and so that's part of the motion. But jurisdiction is established against him at a very minimum for those uncovered medical expenses just by virtue of the DOR proceedings being in place from the child support hearings. So, Your Honor, the case cited by Mr. Chandler, lastly, this Jesse versus State of Florida Department of Revenue, did not deal with Chapter 55 and did not also, that dealt with a modification proceeding and not an enforcement proceeding, which I think is a significant distinction between the two issues. And so, Your Honor, we think the jurisdiction has been established for those reasons. And we'd ask the court to deny the motion to dismiss / motion for protective order.
Okay. Mr. Chandler, would you care to respond?
Yes, sir. I'll be brief. First of all, I am not aware of a DOR proceeding that Mr. Silverio was telling you about. I am not aware of a proceeding. Now, there's a difference. Proceeding inquires that there's court action or infers that there's court action. As far as I know, there is not a court action. If it is, it's sure not in Collier County. There basically DOR is the collection agency, essentially, but there's not a proceeding. So I unless I can be directed to a case number from Mr. Silverio, I don't think the right word is proceeding. Might be, again, collections, or it's paid through the state disbursement unit, but not a proceeding. Judge, the issue here is, do we even have, one of the issues at least is, and this wasn't discussed, is one of the children is an adult that they're seeking to enforce this on. And that child doesn't even live here in Florida. The child lives in Indiana and goes to college in Indiana. So, I mean, again, we're trying to get, could they have filed this in Indiana because that child lives there? Jurisdiction is proper where the payor resides, where you're seeking to enforce a judgment against someone. When in Mr. Silveria's argument, he said, well, there's a distinction between modification and enforcement. And I disagree. You either have jurisdiction or you don't. I don't think you have jurisdiction for enforcement, but not modification, or vice versa. You either have jurisdiction or you don't. The court here would have jurisdiction over the children for purposes of parenting issues, if being domesticated, but not necessarily for enforcement of monetaries against an out-of-state resident. So certainly if we were seeking modification or enforcement of the parenting plan, I think this court does have jurisdiction. But for purposes of collecting unpaid medical issues, I don't think this court has jurisdiction. Mr. Wiley has not asked this court for any relief other than this motion to dismiss or modification of parenting. So I would stand by the court does not have jurisdiction. We would ask that the court grant our motion to dismiss. And the wife, that does not preclude the former wife from seeking relief. She still can. This doesn't shut her door. It just shuts her door in Florida. She needs to go to Nevada because, you know, realistically, even if they were successful here and got a judgment, what is she going to have to do? She's going to have to go to Nevada and record it and enforce it. So why are we wasting time and money here in Florida trying to get a judgment that is unenforceable here, or it would be enforceable here in Florida, that she's going to have to go to Nevada to enforce anyway? So I would ask the court to dismiss, and she certainly can go to Nevada and file whatever she needs to file.
Okay, thank you, Mr. Chandler.
Yes, sir.
Mr. Chandler, I recognize that the response of memorandum, I didn't hit my smart bench till April 30th, and you may not have had much time. Do you want time to file a written response to that? Because obviously it addresses issues that were not raised in your motion to dismiss.
It does. I don't believe, and hold on, let me pull it back up. I'm sorry. I don't believe that the chapter, I mean, again, the chapter.
Sure. The question is, do you want time to have to file a response or a reply to the response? That's really the only question. If you do,
okay,
or don't, this is up to you.
Can I have just one?
Yeah.
I know it was filed on Friday. I wish I'd had a little bit more time. It was filed sometime Friday, and I looked at it yesterday for the first time.
I know that's a little bit of the problem, because I feel like in somewhat you guys are arguing like ships passing in the night.
Well, I guess my issue is I do want to look at the 55505 argument that he's making, to see if there's any cases that support, because again, my concern is, and I don't want to beat a dead horse here, but I don't see that necessarily confers jurisdiction. But if I could have a few weeks to formulate a response,
not weeks, but
at least till next Friday.
Next Friday, Mr. Savario, any issue with giving till next Friday to file a reply?
No, Your Honor.
Okay, so here's what's going to happen. I'm going to reserve I'm not going to make a ruling today. I do want to give Mr. Chandler an opportunity to file a reply, mostly because I don't feel like I don't feel like the motion and the response were almost addressing the same things. So it was hard for me to follow today the arguments without really giving Mr. Chandler an opportunity to address the case law and the statutes cited by Mr. Salvario. So what we'll do is I'll have Cheyenne try to schedule something for a very brief status after Friday, or not this Friday, the next Friday, where after I've had a chance to review, I'll give a ruling.
Yes, sir.
Very well.
Right.
Your Honor.
Okay. Anything else?
That'd be Friday the 14th, Your Honor, correct?
Yes.
Yes. I think your client does have a question, Mr.
Okay.
Chandler. I don't know if you want him to ask it.
Here, I don't, you can certainly call me in a few minutes if you have a question for me, but anything you say now is on the record, so. Okay.
All right. Any questions, Mr. Silverio?
No, Your Honor. Thank you.
Okay, thank you. Bye.
Have a nice day.
Bye, everybody.
Speaking.
Good afternoon, or good morning, Mr. Knight.
Good morning. I apologize profusely. We had miscalendared this, and I know we were supposed to be here at 9, but hopefully.
It's okay. It happens.
Yes.
All right. So we're here today in the case of Mung versus Zen, 20 DR 2378. This is a final hearing, correct?
Yes, correct. Judge, before we begin, my client's first language is not English. His language is Zomi, an ethnic language from Myanmar. I asked him if there is anyone else in Collier County who speaks Zomi. It's only him. So
I figured.
I've spoken to him in English repeatedly. He always seems to understand me. He always responds cogently. But if we slip up, please allow us a little extra time.
Absolutely. All right. Is there any reason, Mr. Knight, we shouldn't proceed to final dissolution today?
No, none.
Have you provided a final judgment to the court?
I believe that my associate Dustin provided you with one yesterday.
All right, I'll take a look. I don't think I have it. I don't have it in front of me, but that doesn't mean it.
Load it up via chat.
Hold on a second. Let me see. No, I don't have it yet. But
would you like me to upload it via the chat application?
No, send it to Cheyenne whenever you can. But
Yeah,
let's proceed. Madam Clerk, can we please try our best to swear in Mr. Mung?
Have him raise his right hand, please. Do you solemnly swear or affirm that the testimony you shall give will be the truth, the whole truth, and nothing but the truth?
Yes. Oh, loud voice.
Yes.
Can you please state your name and date of birth for the record.
Palmung, Pal Kanmung, December 10, 1973.
Okay. Please proceed, Mr. Knight.
Sir, who are you married to?
Lian Zhen,
And when were you married?
April 4, 2006.
Have you lived in Florida for 6 months continuously before we filed this divorce petition?
Yes,
Were you or your wife a member of the United States Armed Forces in the 30 days before you filed?
no,
Are there irreconcilable differences between you and your wife?
yes,
Where does your wife live?
Myanmar,
Okay, do you know exactly where she lives?
I don't know.
Okay. Is there any possible way to contact your wife?
No,
Okay. Do you have children by your wife?
yes,
Where are your children?
Myanmar,
Are you in contact with your children?
no,
Why are you not in contact with your wife or your children?
I don't know.
Are you a refugee?
Yes,
Okay. Do you have any contact? If you were, do you know how to contact your wife or your children?
what? Say again.
Engels, are you able, in any way, shape, or form, able to contact your wife or children? Do you have your wife's telephone number?
No,
Do you have your wife's address?
I don't know.
Do you have any contact information for your wife at all?
No,
Okay. As far as do you know if your wife is pregnant?
no,
Okay. Do you have custody of your minor children? Do your children live with you?
no,
Okay. Do you believe, Ingles, you've lived here in Florida for over 6 months, correct?
yes,
Okay. But your wife and children, they do not live here in Florida, correct?
yes,
Okay. So you are not asking the court to award custody of your children, correct? You're not asking the court to make a decision about your children, correct?
yes,
You're not asking the court to make a decision about any assets you and your wife have, correct?
yes,
You're only asking for a divorce, correct?
yes.
Nothing further, Judge.
Mr. Knight, are there any marital assets or liabilities for the court to divide?
None to our knowledge. My client is a refugee. He's here he came here with just his clothes on his back.
Okay. All right. The court has heard the testimony and reviewed the file. It finds the default was properly entered in this matter on April 9th, 2021. The court finds there's jurisdiction over the subject matter and the parties, that in this case, the petitioner has been a resident of the state of Florida for 6 months prior to filing this petition. And the court finds that the marriage is irretrievably broken and there are no marital assets or liabilities for the court to divide. The court will therefore dissolve the marriage and restore the parties back to single status. However, the court is not making any determinations whatsoever as it relates to the parties' minor children. It will reserve jurisdiction, I guess, if the issue comes up later. Mr. Knight, do you have any questions about the court's ruling?
None.
Okay. Once we receive the final judgment, I will sign it, and best wishes in the future.
Thank you very much, Judge.
Thank you.
Bye-bye.
Bye. All right, I'm going to head to the courtroom.
Okay, I'll hop on Zoom with the other login.